G'day everyone, and welcome to the fourth and final video for week 2 in Laws 3006 Administrative Law. This is the final video in what's really been quite an intense week of content. Honestly, don't hit yourself over the head if you've had to replay any of those videos a couple of times in order to wrap your head around the materials. It takes time. This week, we're focusing on the fact that you can only review a decision of an administrative character made under an enactment. We've done a whole video looking at what we mean by a decision. And then we've done another video looking at what we mean when we say the decision has an administrative character. Now, finally, we come to the last bit, under an enactment. To do this, we're going to start by reviewing some of our basic principles of administrative law. And then we'll look at two key cases called ANU and Burns and the Griffith University and Tang. Sometimes you'll see these cases referred to, for obvious reasons, as the university cases. Okay, basic principles first. At the very outset of this course, we talked about the fact that administrative decision makers are not special. They're just like you and me. The only difference is that the Parliament, in a piece of legislation, has granted them a specific power, which must be used in accordance with the rules which are also established by the Parliament. You might remember last week we followed this through for a passport application. What this means is that for those decisions, we should be able to look and find the enactment under which the decision is made. The enactment which gives the power to the public servant to make the decision. This is super difficult to explain in the abstract. It makes a lot more sense when you apply it practically. So let's dive into those university cases. In the ANU against Burns, Professor Burns became unwell and took an extended period of sick leave. Eventually, the university felt that it was necessary to consider whether he should return or whether he should be invalidated out of the university. The University Council met to consider this decision, but in the meanwhile, Professor Burns obtained some additional medical evidence. He wrote to the Council to ask them not to proceed with his termination until they had considered the new evidence, but they went ahead and ended his employment anyway. Professor Burns claimed that this was what's called a breach of the hearing rule of natural justice. We'll learn all about natural justice in coming weeks. But he sued the university. The question was whether this was an administrative decision made under an enactment of the Parliament. Now, initially this seemed like it should be relatively simple. The ANU, like all universities, is formed by the passage of an Act of Parliament, in this case the Australian National University Act 1946. It seems to follow that decisions made by the council established under that Act to run the university established under that Act should be decisions made under an enactment. However, the High Court found that this was not so. You see, the university's ability to sack Professor Burns came from his contract of employment, not from the legislation. The legislation gave the university the ability to hire staff, so the ability to enter into contracts of employment, but the content of those contracts was not set out by the legislation. As a result, if Professor Burns had been unfairly dismissed, his remedy was in employment law and not in administrative law. What this case teaches us is that administrative decisions to which natural justice applies, administrative decisions must be made directly under the legislation. Decisions which are not made directly under the legislation are not reviewable administrative decisions. If you think that distinction is a bit confusing, well, you're not alone. I always thought the distinction was a bit fragile myself. The court did clarify it somewhat in the second of the cases that we'll look at, Griffith University and Tang. Ms. Tang was a masochist. No, actually, she was a PhD student, but trust me, they're pretty much the same thing. And it seems like she was actually doing pretty well in her PhD, but then she took the fateful, silly step of making up some of her experimental data. She got found out, and the university decided to terminate her candidacy. Miss Tang took the university to court, claiming that the decision to terminate her candidacy was a decision of an administrative nature made under an enactment, and that she hadn't had a proper opportunity to defend herself. The High Court, following the decision in ANU and Burns, said that just because the institution was created by an enactment didn't mean that every decision made by that institution was automatically an administrative decision. The court repeated the finding in ANU and Burns that the connection had to be sufficiently direct. The court said the determination of whether a decision is made under an enactment involves two criteria. First, the decision must be expressly or impliedly required or authorised by the enactment. And second, the decision must itself confer, alter, or otherwise affect legal rights or obligations. And in that sense, the decision must derive from the enactment. Look, this is all still pitched in very general and complicated terms, isn't it? Let's try and break it down. First, the decision must be expressly or impliedly required or authorised by the enactment. This means the legislation has to create the specific power which is being used to make the decision under review. So let's imagine two hypothetical university acts. One of them says the university may terminate the candidature of a PhD candidate if the PhD candidate engages in academic misconduct, including by falsifying data. The second one says the university may make rules regarding admission to candidacy for the degree of Doctor of Philosophy, the conduct of the candidacy, and the award of the degree. Can you see how, in the first case, let's have a look at it again, in the first case, the decision to kick the candidate out for cheating would be made directly in accordance with the legislation. The legislation specifically grants the university that power and sets out the circumstances in which it can be used. In the second case, however, the legislation does nothing of the sort. It creates a very general power and invites the university to make more concrete rules about how those powers would be exercised. You can see that in this case, the power is indirect. It's not expressly required or authorised by the enactment. Similarly, a decision under the first version, a decision to kick someone out for misconduct, affects the legal rights and obligations of the parties. So after the decision, the PhD candidate is no longer a candidate. In the second version, though, where the Act authorises the making of rules, those rules themselves don't actually change any rights or obligations. It takes something further, a decision under those rules, for that to happen. Now, I'm not going to pretend to you that this distinction is really clear. It's one of those things where people really can argue the toss back and forth, and that's why advocacy is important for lawyers. But at least we have those two guidelines: expressly or impliedly required or authorised by the enactment, and the decision has to confer, alter, or otherwise affect legal rules or obligations. So this brings us to the end of week 2. This week we looked briefly at jurisdiction, the question of how specific courts and tribunals get the power to review administrative decisions. And then we dug deep into the question of what a reviewable decision actually is. It can be a decision, the failure to make a decision, or conduct related to the making of a decision, provided that conduct is not a mere stepping stone. The decision then has to be administrative in character, so not judicial in nature, not legislative in nature, not prerogative in nature. Finally, the decision has to be made under an enactment, which means it must be authorised or required directly by the legislation in a way that affects the rights and obligations of the parties. Adding all of this up, we can review decisions of an administrative character made under an enactment. Next week, we're moving right away from this stuff and looking at how our system of administrative law developed. However, for the rest of the course, I'm going to assume that you understand what I mean by a decision of an administrative nature made under an enactment. If you start to struggle with that, you may need to return to these videos, letting the knowledge build and build. I look forward to seeing you next week.